Hi friends, in this video we are going to deal with the important and latest Supreme Court judgments pronounced now in the area of constitution, contract and criminal procedure. To know more about them, please watch the video fully. In the important judgment titled Muhammed and others versus State of Kerala and others, pronounced on 18th February 2022, the Supreme Court has upheld a Kerala government order which granted exemptions to several existing board employees from the qualifications under the Central Electricity Authority measures relating to safety and electric supply regulations 2010. The facts of the case would be that the government of Kerala notified a transfer scheme revesting all the functions, properties, interest, rights, obligations and liabilities that was with Kerala State Electricity Board. A tripartite agreement was entered into between the parties to assure them that the terms and conditions of service shall continue to be regulated by the extant regulations. By a GO exemption from acquiring qualifications stipulated under Regulation 6 and 7 of the regulations was granted to the erstwhile employees. A writ petition was filed before the High Court for declaration that Regulation 116 is ultra vires the regulation making power of the Central Electricity Authority under the Electricity Act 2003 and therefore void. The petitioner also sought for declaration that the state has no power to allow a deviation under Regulation 116(1) in respect of qualifications prescribed in Regulation 6 and 7. A further relief of declaration that the order issued by the state as arbitrary, illegal, unreasonable and without jurisdiction was sought in the writ petition. The single judge passed order in favor of the writ petitioner. On appeal, the division bench held that the Regulation 116 is neither ultra vires the Electricity Act nor manifestly arbitrary. It also held that the framing of Regulation 116 is not beyond the scope of the rule-making power of the Central Electricity Authority. It further held that the exemption from the applicability of Regulation 6 and 7 by the order can be granted only in favor of persons employed on the date of formulation of the transfer scheme and such of those employees who joined service after 31st/10/2013 were not entitled to such exemption. Therefore, the Kerala State Electricity Board Limited was directed to make promotions strictly in accordance with the provisions contained in Regulation 6 and 7. Being aggrieved, the present appeals have been filed with allegation that the government does not have the power to grant exemption, and single judge correctly held that Clause 2C of the tripartite agreement is ultra vires the Electricity Act. The Supreme Court has held that Regulation 116 empowers the central or the state government to allow deviations in respect of matters referred to in the regulations by an order in writing. This court is not in agreement with appellants that granting exemption to the erstwhile employees from possessing the qualifications provided in Regulation 6 and 7 is an impermissible exercise of power under Regulation 116. Prior to the regulations, the Indian Electricity Rules 1956, framed under Section 37 of the Indian Electricity Act 1960, were in force. Rule 133 of the rules would show that state or central government were empowered to grant exemption from the safety provisions contained therein. The power of the exemption was in existence even prior to Electricity Act. A perusal of the order would demonstrate that the state directed deviations from the implementation of the qualifications prescribed under Regulation 6 and 7. Though the word exemption was not employed in the order, the effect of the direction issued by the government was to exempt the employees from the prescribed qualifications. Therefore, this court is in agreement with the division bench that the order cannot be said to have been issued beyond the power conferred by Regulation 116. The interpretation of the relevant provisions, promotion and other service conditions of the officers and employees transferred to Kerala State Electricity Board Limited under the transfer scheme are protected under section 131 and 133(2) of the Electricity Act in conjunction with the transfer scheme and the tripartite agreement. The explanation to section 133 makes it clear that officers and employees referred to in the section are only those officers and employees of the board on the date of transfer scheme. By no stretch of imagination can this protection be extended to the employees who were engaged after 31st October 2013. The High Court was right in setting aside the order which permitted deviation from Regulation 6 and 7 to all appointments made till the date of issuance of order, even after transfer scheme. As the exercise of the power by the state in issuance of the order is well within its jurisdiction, grant of exemption in favor of erstwhile employees cannot be termed as arbitrary. However, the extension of the continuity to employees appointed after 31st October 2013 is not reasonable, and only the transferred employees are entitled for protection of their service conditions. Therefore, this court approves the findings recorded by the division bench. Coming to the next important judgment, titled Universal Petrochemicals Limited versus BP PLC and others, pronounced on 18th February 2022. In this judgment, the Supreme Court has disallowed the claim for damages raised in lieu of specific performance of contract, citing the reason that the plaintiff had not specifically sought the relief of compensation in the plaint. The facts of the case would be that the appellant filed a suit for specific performance of a collaboration agreement as modified by the supplementary agreements. The plaintiff further prayed for declaration of perpetual injunction. The single judge refused to grant a decree of specific performance of the agreement. However, a decree of injunction as prayed for was granted. Aggrieved thereby, the appellant filed an appeal questioning the judgment of this single judge to the extent that no relief was granted. The appeal was dismissed by a division bench. Being aggrieved, present appeals have been filed with allegation that the relief of specific performance of the collaboration agreement cannot be granted by this court as the collaboration agreement expired on 31st December 2009. He further submitted that the appellant is entitled for damages for the period from 24th August 2005 till 31st December 2009. The appellant relied on Section 21(5) of the Specific Relief Act to buttress his contention for awarding damages in lieu of specific performance of the collaboration agreement. The counsel appearing for the respondent contended that the appellants failed to plead relief for damages either in the civil court, before the High Court, or even before this court. She also contended that even assuming that the collaboration agreement expired on 31st December 2009, the appellant did not raise this ground or seek to amend the relief during pendency of this appeal for the past 13 years. The only point that arises for consideration is whether the appellant is entitled for damages for the period between 24th August 2005 and 31st December 2009. The Supreme Court has held that even the appellant admits that no relief or damages or compensation was claimed in the suit. Admittedly, such a relief was not sought for either before the division bench or before this court. No steps were taken to amend the appeal even after the date of expiry of collaboration agreement. The scope of section 21(4) and 5 was examined in Samsu Sugara BV versus G. Alex and another 2004-8 SCC 569, where this court has held that the High Court has clearly erred in granting the compensation under section 21 in addition to the relief of specific performance in the absence of prayer made to that effect either in the plaint or by amending the same at any later stage of the proceedings to include the relief of compensation in addition to the relief of specific performance. Grant of such a relief is in the teeth of express provisions of the statute; to the contrary is not permissible. Therefore, the appellant is not entitled to claim damages for the period between 24th August 2005 and 31st December 2009. The single judge expressly mentioned that the appellant did not claim any relief for damages. Even in the appeal, no relief for damages was claimed. In fact, it was a specific submission by the appellant before the division bench that no relief in the nature of damages and or compensation could be granted. It might be true that the appellant was interested in the relief of specific performance of the collaboration agreement when he filed SLP in 2008, as the collaboration agreement subsisted till 31st December 2009. However, even thereafter, no steps were taken to specifically plead the relief of damages or compensation. For the above mentioned reasons, no relief can be granted to the appellant. Now we are going to deal with the important judgment titled BABU, Venkatesh and others versus State of Karnataka and another, and pronounced on 18th February 2022. In this judgment, the Supreme Court has held that a magistrate cannot entertain an application under section 156(3) of the CRPC when the complaint was not supported by an affidavit. The facts of the case would be that the accused obtained blank stamp papers from the complainants and created sale agreements by misusing the said blank stamp papers, and thus committed forgery and cheated them, and as such they are liable for punishment for offences punishable under sections 420, 464, 465, 468 and 120B of the IPC. The second additional chief metropolitan magistrate directed the police to register FIR. The accused thus approached the High Court alleging that the order under section 156(3) of the CRPC was passed in a mechanical manner by the magistrate. The High Court, however, dismissed their petitions. Being aggrieved, the present appeals have been filed with allegation that the magistrate was required to apply his mind before passing an order under section 156(3) of the CRPC. It was further submitted that unless an application under section 156(3) of the CRPC was supported by an affidavit duly sworn by the complainant, the magistrate could not have passed an order under the said provision. It was further submitted that the dispute was purely civil in nature and the criminal complaint was filed by the respondents only to harass the appellants. The Supreme Court has held that though this court has cautioned that power to quash criminal proceedings should be exercised very sparingly and with circumspection, and that too in the rarest of the rare cases, it has specifically certain category of cases wherein such power can be exercised for quashing proceedings. Facts on record would show that though civil suits were filed with regard to the same transactions, and though they are contested by the respondent number 2 by filing written statement, he chose to file complaint under section 156(3) of the CRPC after a period of 1.5 years from the date of filing of written statement with an ulterior motive of harassing the appellants. This court has clearly held that a stage has come where applications under section 156(3) of the CRPC are to be supported by an affidavit duly sworn by the complainant who seeks the invocation of the jurisdiction of the magistrate. In an appropriate case, the magistrate would be well advised to verify the truth and also verify the veracity of the allegations. The applications under section 156(3) of the CRPC are filed in a routine manner without taking any responsibility, only to harass certain persons. Prior to the filing of a petition under section 156(3) of the CRPC, there have to be applications under section 154(1) and 154(3) of the CRPC. This court emphasizes the necessity to file an affidavit so that the persons making the application should be conscious and not make false affidavit. In the present case, the magistrate, while passing the order under section 156(3) of the CRPC, has totally failed to consider the law laid down by this court. When the complaint was not supported by an affidavit, the magistrate ought not to have entertained the application under section 156(3) of the CRPC. The High Court also failed to take into consideration the legal position enunciated by this court. Thus, the continuation of the present proceedings would amount to nothing but an abuse of process of law.